Good morning, everyone, and good morning to those of you on Zoom. Lovely to see you both in person and online. I want to welcome you to the second annual Kernighan Center's Art Symposium, which this year is co-sponsored by the Responsible Art Market and the U.S. Committee on the Blue Shield. And we're going to get to thank our official financial sponsors later, but certainly for organization, those two organizations have been instrumental in putting this together. My name is Pippa Loengard. I'm the executive director of the Kernighan Center here at Columbia Law School, and we're thrilled to welcome you to the university for Protecting Cultural Property, the 1954 Hague Convention at 70. I'm going to take care of logistics. Patty Gerstenblith and James Reep are going to do the introductory keynote, but I just wanted to go over some of the basics to get you settled in today. For those who are in person, we have a coat check upstairs. Feel free to use that. Will be manned all day if you want to leave things there. Bathrooms are past the elevators on the right, should you need those. We ask that if you do want CLE, we do offer New York CLE, that you sign in and out at the end of the day. The CLE sign-in is by where you got your name tags and registration. The Wi-Fi, you might have noticed cellular service is a little spotty down here, apologies, but the Wi-Fi is free and ample. It's just Columbia University Wi-Fi, no password is necessary. So as a courtesy to our friends who are attending remote, and we have hundreds of registrants in Zoom land, so we're thrilled to have them. We do ask that after breaks, that everyone comes back to the room so we can start the sessions on time. For those of you in the room, you each have a microphone at your desk. We ask that if you are going to ask a question that you speak into the microphone so our friends in Zoom land can hear you. You have a little button in front of you that says speaker. You can push that and the light will turn red on your microphone. You'll know it's on. And also please remember to turn it off when you're finished speaking. Speaking of questions, because we have over 400 registrants online, we will not probably be able to take questions from our online viewers. We apologize in advance for that. It's just logistically going to be very, very difficult to monitor those as well as the in-room queries. With that, I do want to thank our financial sponsors who've really made a difference. You all enjoyed a breakfast courtesy of the Art Risk Group, Sullivan and Worcester, Thompson Hine, Goldman Sachs, the Responsible Art Market, the U.S. Committee on the Blue Shield. They sponsored our upcoming lunch, which is going to be fantastic. And we'll speak a little bit about that at the end of the second panel. And I especially want to thank everyone at Columbia who has worked so hard, our AV department and our Buildings and Services department, and most of all, Samara Weiss, our program coordinator, who is responsible for basically this whole thing actually working. So I'm going to hand it off to Patty Gerstenblith and James Reep for our keynote address.
Thank you. Good morning. For those of you who have a printed schedule, I'm not Jane Levine, but you'll see her later. I'm James Reep. I'm a faculty member at the University of Georgia and the vice president of the U.S. Committee of the Blue Shield. And it's really a pleasure to introduce our keynote speaker today, because Patty Gerstenblith, who is a distinguished research professor of law at DePaul University and the faculty director of the Center for Art, Museum, and Cultural Heritage Law. She's known internationally for her scholarship on protection of cultural property during armed conflict and the issues of the illegal or legal trade in antiquities and other cultural objects. She was a founding member of the U.S. Committee of the Blue Shield and has served since 2020 as the president of the organization. And she is also the chair of the International Blue Shield Working Group on countering trafficking in cultural objects. So it's a pleasure to welcome Patty to the podium.
Well, thank you so much, both to James Reep, who just introduced me. He did not mention he is the vice president of the U.S. Committee of the Blue Shield. And following up on Pippa's announcement, I guess I'll get the business part out of the way, which is that, as she mentioned, the lunch is being sponsored by Blue Shield. And it will be an opportunity. We have most of our board members are here in person today. And it'll be an opportunity for you to meet the board and to learn more about the organization. So I hope many of you will be able to join us for that. I particularly want to thank from Columbia, of course, Pippa Lovengard, who just introduced herself. I want to thank Samara Weiss, who really has helped to put this together. Kathy Kaplan, who teaches here at Columbia Law School and does many other things as well. Nick O'Donnell and Birgit Kurtz from the Responsible Art Market. And from the Blue Shield, I want to thank our executive director, Rachel Dewan, who unfortunately could not be with us today, but Jane Levine, who really worked a lot and is our nexus between the Blue Shield and Columbia. So I wanted to thank all of those individuals. Now, this is, again, as Pippa mentioned, it is an important anniversary this year, 3 important anniversaries, in fact. It's the 70th anniversary of the 1954 Hague Convention, if your math is good enough to figure that out. I always have to stop and think about it myself. But it's also the 25th anniversary of the second protocol. There was a first protocol, which is also from 1954, but the second protocol, which was finalized in 1999 and came into effect in 2004. And I will refer to that again in a few minutes. And very important for us here in the United States, it is the, if my math is right, the 15th anniversary, finally, of the US ratification of the convention itself. We have not, the US has not ratified either the first or the second protocol, which is something that we at Blue Shield would like to try to work on. Many countries have done so, a few have not. And again, that's something I will come back to in a bit. Before I begin, I also want to pay tribute to 2 really legendary, significant figures in the world of cultural heritage protection and cultural heritage law, both of whom passed away in the past few weeks. First, on the right is Professor Francesco Francione, sorry, on your left. Professor Francione was a professor at the University of Siena in Italy, and then the European University Institute in Florence. Almost every European lawyer who works in the field of cultural heritage law was trained by him at some point in their career. I really cannot overstate his influence and significance to the development of this area of law. He was very active in the drafting of many of the UNESCO culture conventions, and he also served as president of the UNESCO World Heritage Committee. Most recently, he submitted an amicus curiae brief in the case before the courts in the Netherlands on the return of the Scythian gold pieces to the country of Ukraine, to the national government in Kyiv, rather than to the museums in Crimea. The objects had been loaned from the museums in Crimea, but if they had, before 2014, before the annexation of Crimea, and if the objects had been returned, they might well have been carried off to Russia proper, to probably the Hermitage, to be lost to the Ukrainian people. He took a very nuanced position on how the 1970 UNESCO Convention should be interpreted to apply for the return to the national government. And he was, in fact, successful in that. And finally, a subject we'll return to at the end of the day, he played a key role in the development of the nexus between human rights and cultural heritage law. So, as I said, his significance cannot be overstated. The second individual who passed away just this past week, Patrick Boylan. My experience with him focuses primarily on the fact that he wrote the review of the Hague Convention in 1993 at the request of UNESCO to determine how effective was the convention, what needed to change. And it was this review, which is enormous, very long, led to the drafting and adoption of the second protocol to the convention. He served as the founder and vice president of ICOM, the International Council on Museums. And it was he who brought together the leaders of the main international organizations involved with archives, libraries, and ICOMOS, the museums and sites, along with the museums, to found the Blue Shield movement in 1996. So he really is the founder of our movement. In addition to his work in cultural heritage, he worked in museums, arts and archives services in England, and he became a professor at the City University of London. He wrote, and I will quote in the foreword to his 1993 review, because this really informs much of what we do. The loss of the physical or spiritual cultural heritage of one people is a loss for the whole of humanity. This loss is not just a loss for the people or community directly deprived of the evidence of their own past and present culture. The consequence is ultimately no less grave for those who may have deliberately brought it about. It is not unreasonable for the world community to seek to protect its cultural inheritance, pass it on to future generations, even in the most extreme emergencies of war. So this really is, to a large extent, our guiding star of what we try to do, not just at the Blue Shield, but more generally for all of us who work in this field. And with that, I will start. And while I'm going to begin with a somewhat historical overview of how, I should back up and say I was asked to speak now in a way that would bring everybody kind of up to the same point. Some of you I know have worked in the field of cultural heritage law, cultural heritage protection for many, many years, but some of you are not as familiar with the subject, particularly perhaps those of you who are online. So please bear with me as I give something of an historical overview. And then my goal is to highlight the issues that remain, some of which are improved or informed by the second protocol, but others which we have to work on as a community to try to improve the protection of cultural heritage during armed conflict. So let's see, how is all this working? Here we go. For the moment, at least, I guess, well, no, I'm going to come pace. But the problem is I'm tethered to this, so I can only pace so far, but it helps. At least I can look at the slides myself. So I begin where I'm actually going to end up, which is with Ukraine. This is the theater in Mariupol. You may remember over the past 2 years, we're just past the 2-year mark of the invasion of Ukraine. You may remember that the theater was bombed by the Russians fairly early on in the conflict. And while it was the destruction of a cultural site, a theater, I also use this as my beginning point, because we must always remember that the significance of cultural heritage lies in the people. And in the theater, about 1,200 civilians had taken refuge, thinking they would be protected. But in fact, the building was bombed anyway, and about half the people there, about 600, died as a result. So even as I talk about, and many of us will be talking about, what seems to be objects and places and structures, it is the people that give it meaning, and it's the people we must always remember. Now, I briefly start in antiquity. Those of you who know me know that I have a background in archaeology, so I have to start in antiquity. But the looting and destruction of cultural sites, particularly religious sites, was very common in antiquity. And it was done for a number of reasons. The conquest was done to show to the people who are conquered that they have in fact been conquered. And many times they have to lose their culture or lose their religious beliefs in order to be absorbed into the larger conquering military. And so I use the Arch of Titus that illustrates the destruction of the Second Temple in Jerusalem, roughly 70 CE. And you see here that they have carried off the major religious implements, excuse me, the menorah and other religious sacred objects that would have been used in the temple. And it's being brought to Rome to show that the conquest, the might of the conqueror, and that the conquered people will be absorbed. They will lose their cultural identity, if possible, according to what the Romans believed. There are other episodes we certainly know from antiquity of destruction of cultural heritage and cultural property. Unfortunately, it's difficult to find of images that really illustrate those well. Now I fast forward some, not quite 2,000 years. There we go, to the time of Napoleon. Oh, as I guess I'm supposed to behave myself. Okay. We see very much the same kind of conduct going on all through the centuries until we get to the time of Napoleon. In the 1790s, Napoleon tried to conquer much of Europe, and as he was doing so, to bring cultural objects, particularly from Italy, back to Paris, because Napoleon's idea was to recreate Paris as the new Rome. Is that better? And one way to do that was to bring particularly objects from, as I said, Italy to Paris, where they were placed in what became the Louvre, the museum that was open to the people as a result of the French Revolution and Napoleonic conquests. But in doing so, Napoleon, and particularly the artists, most of the French artists, not all, believed that by bringing these objects to Paris, they would be best protected. It would improve the arts in France, but also they were acting altruistically on behalf of everybody else in the world because the French were the best equipped to take care of the objects on behalf of everybody else. Little problematic. But you also see here, and I do think I have a, yes, okay, these horses here being brought. Also people, animals from zoos, you can see the lions and the like were being brought from zoos, and camels down here. Were being brought. Now, at the end of the Napoleonic Wars, the British victors, instead of taking the objects back to Britain or to various allies who had opposed Napoleon, they decided not to take the objects, but rather they should be returned to where they had been taken from last. The French were not going to keep them, and the British also would not keep them, but rather they would be returned to the place from which they had come. So in the case of the Laocoon, which is a Roman copy of a Greek original sculpture, but had been discovered in Rome, the Laocoon was returned to Rome. If you want to see it, you can go to Rome and see it there still today. But the horses of St. Mark's, which came, Napoleon took from Venice, had actually, the Venetians had taken in 1204 from Istanbul, Constantinople. And the principle was set that it didn't go back to where they had come from earlier, but rather the place from which the French had taken it, as a way of resolving the disputes among the various allies who had opposed Napoleon. So returning it to the place from which it had most recently come is the simplest, easiest way of doing that. But basically, it set the precedent not to steal, not to loot, and if you do during armed conflict, you need to return at the end. Now, a second legal precedent was established at about the same time. A ship known as the Marquis de Summerall was bringing artworks from Italy to Philadelphia Museum of Art, but it was intercepted by a British warship. Usually I ask my students their little historical quiz, like why was a British ship capturing an American ship at the time? But it was during the War of 1812. It was taken to Halifax, and the Philadelphia Museum asked for the artworks to be returned. The judge there, perhaps without precedent, decided that they were not legitimate war booty, but should be returned to their proper owners. And in fact, the ship was allowed to go on its way with the artworks, which were returned to Philadelphia. But in the 1950s, Philadelphia Museum gave 2 of the paintings back to the museum in Nova Scotia in appreciation for what the judge had done. So between the end of the Napoleonic Wars and the Marquis de Summerall case, we begin to have developing the legal principle that artworks and cultural objects are not legitimate war booty and should not be taken during armed conflict. But if they are, they need to be returned. Present at the Battle of Waterloo, the end of the Napoleonic Wars, was a Prussian scholar, historian, military historian, also a classic scholar named Francis Lieber. He came to the United States. He taught first in South Carolina and then actually came here to what was later became Columbia University. And he, in 1863, was asked by President Lincoln to draft the first written military code of conduct. This covered all aspects of military conduct, not just cultural property. And these principles gradually become part of international law and are embodied in the 1899 and 1907 Hague Conventions, which again address all manners of conduct of war. What is captured here is a debate, which still goes on today, which is what is the most humane way of conducting war? Should it be done all out, get it over with as quickly as possible so that the war ends? Or should there be what we consider to be humanitarian restraints on how war should be conducted? Lieber came down on the side that there should be restraints. Obviously, what the extent of those restraints should be also varies depending on your view. But for instance, he believed that the methods of war should not be so draconian that it made returning to peace difficult. He was opposed to things like and prohibited poisoning of wells. But along with that, he had three core provisions get embodied. One is to prohibit intentional targeting of cultural sites so far as possible. Second is prohibiting the pillage and seizure of cultural objects, and the terms used were different. They didn't use cultural property or cultural heritage as we do today. Third, if objects are taken, they should be a subject of their restitution, be the subject of the terms of a peace treaty, and basically should be returned at the end of the conflict. The two early Hague Conventions remained the international legal instruments for both the First and Second World Wars. There was an attempt in the interwar to draft a new convention, but it didn't get done. And as we know, particularly in the Second World War, cultural heritage was destroyed, stolen, targeted on a massive scale. And I'm not going to spend a lot of time on World War II because there's been so much written about it. I'm going to go over it pretty quickly. But we see here on the left is Canterbury Cathedral in England, which was part of what are called the Baedeker raids. The German Air Force, Baedeker, I tell my students, is kind of like the earlier version of Rick Steves. If you all know who Rick Steves is. Never mind, okay. But it was basically a guidebook, and the Germans seemed to be following a guidebook to destroy as many, particularly cathedrals and religious structures as possible. So that was a quite intentional bombardment. Of course, the Germans also stole and looted throughout much of Europe, and this became a subject of the Nuremberg trials as well, although they were not prosecuted for cultural property theft, but they were for theft of what we call civilian objects, in other words, non-military targets. On the right, it shows Dresden, which was bombed by the British at the end of the war, probably without any actual legitimate military justification. But there was never any prosecution of the British for doing that, possibly motivated by revenge for what the Germans had done. As I mentioned, we know, of course, that the Germans stole as well throughout much of Europe. Just a few examples. On the right, you see Generals Eisenhower, Bradley, and Patton, end of the war, in one of the salt mines where the Germans had put many of the cultural objects taken, particularly from Western Europe. Eastern Europe, the Germans primarily destroyed rather than looting. But in Western Europe, they focused somewhat more on thefts. And of course, the bottom left of the screen is the monuments officers during the Second World War. And we have represented here today the new modern monuments officers as well. Now, as I said, I'm not going to talk a lot about this, but we know there is continuing litigation even through today. Up here on the, what happened up there? Oh, on the upper right, well, behind that little screen thing. Sorry, that's what I most wanted you to see. The Russian war prisoner, these are all drawings by Sheila that ended up in the collection of Fritz Grunbaum, a cabaret artist in Vienna from before the war. And there is still ongoing litigation, particularly concerning the piece in the upper right, which is at the Art Institute in Chicago. I won't go into the details. It's a very complicated case, both factually and also in terms of application of, for the law students who are here, civil procedure principles, statutes of limitations and latches and things like that. Two other cases, relatively recent, address the question, in addition to the question of latches, whether, in fact, when people sold artworks during the war, arguably under duress, whether in fact that qualifies legally as under duress, so that the courts today will treat the sale as the equivalent of a theft. And so far, particularly in the painting on the right, which is at the Metropolitan Museum, you can go over and see it there. Picasso, it's a very famous piece, was held not to have been sold under duress. So this is still very much a continuing story today, litigation involving artworks. One last thing I'll mention here before I leave issues of the works themselves being stolen. We have to think, and there will be a panel later today on the art market. We have to think about what the art market can do today to prevent these kinds of cases from happening in the future, whether it's 20, 30, 40, 50, 80 years in the future. How it's not just about giving back what was taken in the past, it's also about avoiding those situations today. So how can the market avoid acquiring looted, stolen works of art, cultural objects, particularly those taken during conflict? Now, at the end of the war came the main international humanitarian law conventions, particularly the Convention on Genocide, written by Raphael Lemkin. This will come up in the fourth panel on human rights. He coined two terms, barbarism and vandalism. Barbarism is based on writings that he did actually in the 1930s, before the Second World War. Barbarism is what today we call genocide, but vandalism is what we might today call cultural genocide. And these were two crimes that he felt were so heinous, so awful, that there should be universal jurisdiction. People should be able to be apprehended anywhere in the world for committing these two crimes. And the original draft of the Genocide Convention included what we could call, he didn't use the term, but we could call cultural genocide, which included things like destroying not just cultural heritage, but living culture. So it was also languages, religious practices, books, libraries, as well as works of art. However, when it came to actually adopting the text of the Genocide Convention, the side of cultural genocide was omitted, primarily at the insistence of countries like the United States, we could call a settler colonial state, out of concern that how the United States, for example, treated its indigenous population, the Native American population, would be considered to be cultural genocide. At the same time, there was an emphasis on viewing humanitarian or civil rights as individual rights rather than collective community rights. And again, we'll come back to that later this afternoon. But genocide itself gets adopted. There's also the Geneva Conventions, which really don't pay any attention to cultural heritage or cultural property. Protocols from 1977 do, but they are all subject to the provisions of the 1954 Hague Convention. Okay, so very briefly, I'll just mention a couple of the highlights of the convention itself. What is cultural property? And one of the important things, if you look up at the definition, of great importance to the cultural heritage of every people, which raises questions of importance to the global community, universality, or to a country, or to a community. And that is a question that is still not resolved. Covers immovable monuments, structures, and archaeological sites. It also covers movable objects, works of art, manuscripts, books, archives, etc., and repositories. So a museum that does not otherwise qualify as an historical structure would still fit the definition of cultural property as a repository of objects that are cultural property. The Hague Convention, the two core obligations are to safeguard and to respect cultural property. Safeguarding is things that should be done primarily in peacetime, proactively to protect cultural heritage in case of armed conflict. And respect is basically things not to do. Number one being to refrain from directing acts of hostility against cultural property, unfortunately subject to what is known as the military necessity waiver. So cultural property, in fact, can be targeted, subject to imperative military necessity, which the convention does not really define. even though this was based on General Eisenhower's orders to the Allied troops before D-Day. And he spelled out that necessity is not a matter of convenience. It should actually be necessity. But that's something I'm going to come back to in a few moments. Third, prohibits and prevents theft, pillage, vandalism, et cetera, directed against cultural property. We also have Article 7, which calls for establishing in the military the expertise that you need to protect cultural property, to educate the military, to have specialists who can secure respect for cultural property and work with the civilian authorities in territory that's being attacked. First protocol, I'll just mention quickly, prohibits the removal of cultural property from occupied territory. And the second protocol from 1999 introduces the principles of proportionality, feasibility, and distinction. Proportionality, meaning that if cultural property is to be targeted, the amount of damage should be proportionate to the expected military advantage. It narrows the definition of military necessity. It requires countries to adopt criminal provisions for serious violations. And it also designates Blue Shield International as a consulting body to UNESCO on protecting cultural property in armed conflict. There we go. And I'll just show you an example. There are images of Blue Shields throughout the presentation, but this happens to be my favorite one, which is the Blue Shield painted on the roof of the museum, the Iraq Museum in Baghdad. Corey's frowning at me. Okay. Which is not the way it really works. It's not like you have military jets flying overhead and they say, oh, there's a Blue Shield, we will bomb it. But still, it was an effort in 2003 by the Iraq Museum professionals to show that the museum was a protected entity during 2003 Gulf War. We know that the museum, first of all, the libraries and archives were burned in the chaos, the vacuum of power in Iraq in April of 2003. The museum itself was looted and damaged. You can see in those two images. And I guess I'm coming back to the point I made about the market, which is objects that were stolen from the museum still show up on the market. And this is one example over here, this is actually quite a small piece, which was from the museum, documented in the museum collection, nonetheless bought by the Michael C. Carlos Museum at Emory University back in 2006 with no prior provenance history, buying a piece from Iraq at that time without provenance. A little problematic, but it was returned just about exactly a year ago to the Iraqi authorities. There we go. In addition to the looting of the repositories, the archaeological sites, particularly in southern Iraq, were looted on a massive scale. I do want to thank Professor John Russell for this image and a couple of the other images that I've shown. And you can see, this is an aerial view here. You can see looters on the site as well. One of the points I'm going to make is how documentation has changed over You want me to go back? You force me to. You force me to. It's not fair. Is it going to be working? Is it working? Okay. All right. Why is there nothing on the screen here? Okay. Is it asleep? Okay. I don't need it. Oh, there we go. Well, we skipped ahead slightly. Let's see if we can. There we go. The methods of documentation have changed. Really, it was the war in Iraq in 2003 that began extensive use of what we call remote sensing of various means, whether it's satellite, drones, and the like, to document damage done to cultural sites. And it really started just by saying, and maybe if you're documenting the looting of an archaeological site, it's sufficient to say, gee, we can see how much looting was done in different time periods, before the war, during the war, after the war, and the like. Today, we know, particularly because we want to use that documentation for other purposes, this is not really sufficient. So keep that in mind, and I will come back to it. And in terms of objects looted from the sites themselves, we know that the Hobby Lobby Corporation purchased, well, in the end, there were about 12,000 objects that either Hobby Lobby Corporation or the Museum of the Bible in DC had. And there was another 5,000 from Cornell University. So 17,000 objects were returned to Iraq in the summer of 2021. And those 17,000 objects had been taken either during the 1990s, after the first Gulf War, or in 2003, after that Gulf War, as well as the Gilgamesh tablet that you see here on your upper right. And it was looted certainly in the 1990s, not later. And it was also returned at about the same time. And you see it here in the museum back in Baghdad. I hope you can see it there. It's kind of a small guy. So again, issues of the market continue of objects stolen during armed conflict that then appear on the market, get purchased by institutions, particularly in the United States, and then we all have to work on returning them. Now, I'm going to mention 2 or 3 sort of unresolved or insufficiently resolved, in my opinion, issues from the convention itself. First, of course, is that military necessity exception. And we have to think about, are we operating under the convention itself or operating under the second protocol, which narrows that definition? Before 2009, the 2 major military powers, the United States and then the UK, but US, of course, the biggest, had not ratified either the convention or the first protocol, or certainly not the second protocol. So the United States ratified it in 2009. So during the actual 2003 war, question of what law applied. So there is something called customary international law, which can apply even in the absence of ratification of a particular convention, and the core principles not to target and not to loot were considered to be part of customary international law. More recently, we have a new version of the military manual, which helps a lot in clarifying some of these issues from the perspective of the United States. But in terms of what is military necessity, on the upper left is a castle, which was a World Heritage Site in Syria called Crac de Chevalier, which in 2012 was attacked, and you see here the explosions, by the Syrian forces. A large number of civilians had taken refuge there, similar to the Mariupol theater that I showed you. Again, thinking they would be safe by seeking refuge within a World Heritage Site, but along with them came some of the Free Syrian Army fighters. And so Assad forces attacked it. None of this was ever litigated in any way, but my guess is that this would be excused under military necessity, particularly under the convention as opposed to under the second protocol. But on the bottom right, you see that the forces of the Islamic State blew up the shrine of Nebi Yunus, the prophet Jonah, in Mosul in Iraq, a site that was religiously significant in Islam, Judaism, and Christianity. Here, there was no conflict going on at the time, and they simply blew it up without any people being attacked or harmed as a result. And I'll come back to this question about conflict in a moment, because arguably there may not have been any conflict going on when the shrine was blown up, that it had already been taken over by the Islamic State. In another example, we have, going back to the Balkan conflict in the 1990s, on the left is the site of Dubrovnik, the World Heritage Site on the coast of Croatia. And that was attacked by Serbian naval forces. Dubrovnik was already a World Heritage Site at that time. And there was an International Criminal Tribunal for the former Yugoslavia that was established. And those Serbian officers were prosecuted by the ICTY. Now, they did lots of other bad things. And with only one exception, whenever anybody is prosecuted for cultural property destruction, they also have done rape, murder, torture, and the like. So they get prosecuted for all that together. But on the bottom right is the bridge at Mostar, which today is in Bosnia-Herzegovina. It was a very important, it was actually named a World Heritage Site after it was destroyed, which is actually, we should talk about that someday. James being an expert on the World Heritage Convention. And it was very important. It was constructed in the mid-16th century when this was part of the Ottoman Empire. And it was also important as a link between not just the two sides of the river, but the two different ethnic religious communities in Mostar. And the bridge was destroyed by Croatian forces. And the Croatian forces, particularly the leader, was convicted in the ICTY for the destruction of the bridge because the destruction was viewed as disproportionate to the military advantage that was expected to be gained. His conviction was reversed by the ICTY on the grounds that the bridge had become a military target. Even though it had tremendous cultural significance and continuing to the current population significance, nonetheless, it had been used by the Bosniak forces and had lost its protection as a cultural site because it had also been used for arguably a military strategic purpose. So again, and this also illustrates the different, this is before the second protocol was written, which has clarified it. But if you don't have countries that have ratified the second protocol, it's not clear how do you sort out what military necessity is under the convention versus what it is under the second protocol and what will be excused or not. Now, I've mentioned that, so we had the ICTY. There used to be ad hoc criminal tribunals established for the enforcement of different principles of international criminal law. The 1954 Hague Convention leaves it to each country to decide for itself how it will enforce the convention. And I've already mentioned the second protocol requires countries to adopt specific criminal provisions. But in 1998 was finalized what's called the Rome Statute, under which the International Criminal Court, or ICC, was established. This requires individual criminal responsibility. Technically, the jurisdiction of the court applies only for states that have ratified the Rome Statute, but in fact, a country can accept, a non-state party can accept the jurisdiction of the court, which, for example, is what's happened with Ukraine. Neither Ukraine nor Russia has ratified the Rome Statute, but Ukraine has accepted the jurisdiction of the court. And you may remember that Putin and another Russian official have in fact had an arrest warrant issued by the ICC, nothing to do with cultural heritage, but for the abduction of children being taken from Ukraine back to Russia. Now, the Rome Statute now there's four, but basically establishes three tiers of international crimes. Genocide, which is based on the Genocide Convention. Crimes against humanity, in which cultural destruction is not directly a crime against humanity, but the targeting of specific cultural and religious sites may be evidence of intent to persecute a particular group. So it can be part of the evidence of establishing a crime against humanity. Third, however, are war crimes, which includes intentionally directing attacks against civilian objects, buildings dedicated to religion, education, art, science, or historic monuments, provided they are not military objectives. Interestingly, this terminology doesn't use cultural property or cultural heritage. It's really a throwback to those early Hague conventions that I mentioned. It's a very kind of, to me, peculiar, archaic way of expressing this. And the looting or theft of cultural objects is not itself a war crime, although arguably would fall under theft of civilian objects, non-military objects. And honestly, I'll just throw this in. This definition of war crimes, which is very limited in my opinion, along with some of what, particularly the decision about the bridge at Mostar, does raise the question of whether particularly international criminal law, some of you are going to get very upset if I say this, but it does raise the question of whether cultural property deserves or receives any protection beyond what civilian objects, non-military objects receive. And I think this is an important question that we need to think about. There was a more recent decision by the International Criminal Court involving the Congo, where there's kind of a throwaway line about how only cultural heritage that is very significant is protected by the Rome Statute. something again to discuss in view of World Heritage Sites, but it's only one throwaway line. I don't want to overstate that too much at the moment. But these are real problems, and if the definition of cultural sites, or what comes under war crime for the ICC, the Rome Statute, gets narrowed to things like just World Heritage Sites, to me that's very problematic for a number of reasons, which I won't go into right now because I don't have time, but something that we should be keeping our eye on. There has been one prosecution I mentioned under the ICC where the only crime was destruction of cultural heritage. That involved the destruction of shrines and mosques in Timbuktu. In Mali, prosecution of Almaty. And he pled guilty, so there was never a full litigation involving that. Some people think, there's a law review article entitled, Almaty was convicted of a crime he didn't commit, because there was no nexus of armed conflict going on right at the time of the destruction of these sites, which raises another important question. How do we define what is the armed conflict? I mean, there is a definition of armed conflict, but more generally, how do we define it so that the Hague Convention, the ICC, the Rome Statute, et cetera, would fall under this rubric of international crimes? Lastly, I want to mention and come back to the idea of how do we document, not just for the purpose of documenting what happened, what gets destroyed, but more generally, how do we document for purposes including possible prosecution of war crimes? Subject that I personally am very interested in. So I show you here a map, courtesy of the Cultural Heritage Monitoring Lab, and actually also Dr. Brian Daniels. I'm not sure if he's come in, one of the board members of the Blue Shield. And you'll see here, very recently, I got this just a couple of days ago, the number of sites that this particular monitoring lab in Ukraine has documented of cultural destruction. There are other statistics that are out there, but I will leave that aside. But it's not enough, as I said, to say that something is destroyed. So to illustrate that, this goes back actually 2 years to the beginning of the conflict. And you see here in the yellow circle an aerial view of a museum called the Ivan Kiev Museum, just north of Kiev. And you may remember that when the Russian invasion started, troops came in from the north trying to capture Kiev. So you can see here the museum. Again, it's an aerial view, so you're looking down on the roof. And then right at the beginning of the war, the museum was burned. And I'm assuming you can all see that. I hope I don't. Okay. So this is the aerial view, again, the same view as you saw a moment ago, looking down on the museum. And I'm going to play a snippet actually from the U.S. Blue Shield conference from 2 years ago, where we had information provided by a group called the Conflict Observatory involving the Smithsonian, the Virginia Museum of Natural History, and the State Department, where one of the leaders of this research explains what they're trying to figure out. Well, let's hope this works.
Now, important to us in this case and other cases is we recognize that it's no longer sufficient to just say impacted or not. At the end of the day, that helps a few stakeholders, a few missions in order to prioritize when and where something needs to be responded to. But also, we need to focus on the context of impact. We can collect some of that information from open sources, formal media, and things like that, but we can also leverage the imagery we have in front of us to make some of those determinations as well. And I should say not make determinations, but make inferences about what might be happening. In this case, you can look at something like the immediately surrounding buildings, all residential in this case, the immediately surrounding landscape, the trees, the vegetation, and identify that very few, if any, of the surrounding environment has been impacted. It is really confined to the building itself. And while an image can never tell us, an image alone can never tell us intent for why cultural heritage is being impacted, we can begin to infer and use this as just one piece of independent evidence, an independent line of evidence to suggest that this might not be collateral. Again, we can't make that determination from the image itself or the image alone, but it does add one piece to that conversation.
So particularly if we were trying to think about, would this be something, prosecution as a war crime? We would need to think about what else is going on. First of all, who was the perpetrator? Here, that's not too difficult to figure out, but there are other conflicts where it can be. What was going on? Is there a military necessity? Is there some other factor? Was it accidental? Now, the inference here is that it was not accidental, that it was intentional. But we would need to have all that kind of evidence collected from a variety of sources, including social media and other things, to try to inform why did this happen, under what circumstances. And one of the questions is, why would this museum have been singled out if it was? And we're not sure about that. But it was a museum devoted mostly to the work of a particular artist, Maria Primachenko, who is a very prominent Ukrainian artist. She passed away in the 1990s, so this was not, she was long gone by now. But she was a leader of this primitive folk art movement within Ukraine. But she was also interpreted as being somewhat anti-Soviet. And it's possible that that might have provided a motivation, because we have to remember that the conflict in Ukraine is in part that Russia wants to show that Ukraine is not a separate country. It should be part of Russia in their view. And part of that is to say that they don't have a distinct culture. And we see that in the types of buildings, we see that in the types of artworks, we also see that in the religious structures that have been attacked by the Russians. So this would provide, if in fact it was intentional, if the museum was singled out and targeted, there doesn't seem to have been any military necessity going on, could it have been for this cultural motivation to destroy a part of the distinct Ukrainian heritage? And I'll just mention here also part of the monitoring that was done, again, an aerial view of the museum in Kherson, not too far from Crimea. As the Russians withdrew from that area now almost a year and a half ago, you'll see the yellow arrows pointing to white vans that seem to have pulled up to this museum. The red roof is the Kherson Art Museum. And they removed hundreds, if not more, paintings from the museum and took them to Crimea. They claimed they were doing it to protect them under the first protocol to the Hague Convention. I'm not sure that the rest of us necessarily buy that. But we can see again how that remote sensing at least can tell us what's happening to a large extent. Here it's going on inside the building. You can't see what's happening inside the building, but we can infer, we can draw conclusions from that the Russians took much of this art collection back to Crimea. So these are some of the questions that I wanted to leave you with, to pose and to leave you with in thinking about. And with that, I thank you for your attention.
Okay, are there any questions? Yes.
Thank you. We appreciate the presentation. Is it important in these discussions that we have definitions of military necessity that are listed by U.S. or allied nations or adversaries, what they consider military necessity and how it's defined by them? Because even the United States says it's just the do any means necessary under the law of war to win the war. That's military necessity.
Say that. First of all, you should introduce yourself.
Yeah, so Colonel Scott DeJesse with U.S. Army Civil Affairs and Psychological Operations Command, and working with Smithsonian team rebuilding the monuments, men and women. But the idea of the definition of military necessity is to win the war as soon as possible with whatever means you have able under the law of war. Shouldn't we discuss those definitions?
Well, we certainly should. And I wish that we could come to, you're a military person, you can probably do this better than I can. I tend to speak in the abstract. But you said all means necessary permitted under the law of war. And that's the catch to it. It's not all means necessary, stop, right? It's under the law of war. So this is, for those of you who may not know, the law of armed conflict and international humanitarian law are basically the same thing. And so under that law, the problem I have is that, and maybe because I'm not an operations person, which you know full well, I work mostly in the abstract. I don't know how you define it for sure. I mean, I think we can have extreme examples on each side. And the example of Dubrovnik is an extreme example on one side, where apparently there was kind of uniform agreement that there was no military purpose whatsoever in attacking the site of Dubrovnik. And we have other times where, for example, the Croix de Chevalier example with Syria, where we might have a different conclusion depending on which international instrument the law of war is. We might, under the 54 Hague Convention, I think it was probably excused. Under the second protocol, it might not have been, and I don't know enough of the facts. I don't know if anybody knows enough of the facts to say whether the damage inflicted was proportionate to the expected military advantage. And that's a determination that I think can only be made on a case-by-case basis, which is kind of unfortunate. But and then there are other examples where it seems to be military necessity, where we would have a consensus on that. Obviously, the problem is the things that fall in between. And I guess I don't want to do this to you, but how would you define that middle ground?
Well, it's always the operational context. And, Dr. Bassett mentioned it's the intent and the environment of what the commanders or organizations are doing. And you could say, well, the center of gravity for a conflict is the will to fight. So the idea of what adversaries do to destroy cultural heritage is destroy their will, because the idea of Ukraine, center of gravity is their cultural heritage, which is why they're fighting. One of the reasons, right? Because they're attacked. But for both sides, both Russia and Ukraine, cultural heritage is the center of gravity. And that the idea you start blurring the lines, because that's a major part of why military operations are conducted, to affect those centers of gravity. So it's always a gray zone, but it's the intent.
Okay. Which is often I think in the case of Ukraine, it's not that difficult to determine overall the intent. As you said, culture and cultural heritage has become really central in the Ukraine conflict. Proving that Ukraine is not a separate country in the Russian view, and of course the opposite for the Ukrainians. But I think there are other circumstances where it's not as clear cut. And it's clear when the US did finally ratify the Hague Convention in 2009, for those of you, the difference between we signed it in 1954, ratified it in 2009. But it's one of the, I can't remember if they called it a reservation. When you ratify an instrument, you can have reservations and clarification statements. And one of them is that the circumstances should be determined by the commander in the field at the time that the US military takes a certain action. The military manual that was issued in 2015, as it had several updates, I think has gone some distance towards clarifying a lot of this, which we didn't have back in 2003 during the Iraq War. But it's hard to determine in the abstract. It's got to be done, I think, on a case-by-case basis, which is unfortunate because then the military commanders don't necessarily know what they can and can't do. Thank you for raising that.
I think we have time for one more question before the break. If not, thank you, Patty. Appreciate it very much.
Thank you all.